Hello. Today we are going to look at the 6th module's second part of discussion, which includes the discussions related to Board of Directors and board process. Director. As per Company Act 1994, Section 2, Subsection F, Director includes any person occupying the position of Director by whatever name called. Section 90, Subsection 3 describes that only a natural person may be appointed a Director. Additional Director. The Directors shall have power at any time and after the expiry of a specified period to appoint a person as an additional director who shall retire from the office at the next following ordinary general meeting, but shall be eligible for election by the company at that meeting as an additional director. Regulation 86 of the Companies Act 1994 is the source. Now let us look at alternate director. An individual who is appointed to attend a board meeting on behalf of the director of a company where the original director is unable to attend is considered or called an alternate director. Independent director. Independent directors play a pivotal role in maintaining a transparent working environment in the corporate regime. Independent directors constitute such category of directors who are expected to have impartial and objective judgment for the proper functioning of the company. The post of independent director is only required for the public limited company listed with the stock exchanges. Consent of director. According to the Company Act 1994, Section 93, consent of director, number 1, is required for every person proposed as a candidate for the office of a director and shall sign and file with the company his to summon a meeting of directors. As per Regulation 88 of Schedule 1 of the Companies Act 1994, a director may and secretary on the requisition of a director shall at any time summon a meeting of directors. The notice shall be in writing. To summon a meeting of directors. As per the Regulation 88 of Schedule 1 of the Companies Act 1994, a director may and secretary on the requisition of a director shall at any time summon a meeting of directors. The notice shall be in writing. Apart from the agenda, the notice should clearly state the followings. Number 1, the chronological number of the meeting. Number 2, date of the meeting. Number 3, day of the meeting. Number 4, time of the meeting. And number 5, place of the meeting. Serving of notice of a meeting. Section 95 of the Companies Act 1994 stated that notice of every meeting of the Board of Directors or BODs of a company shall be given in writing to every director for the time being in Bangladesh and at his address in Bangladesh. So, notice of the meeting of a 304 company along with the statement of the business to be transacted at the meeting shall be served to every member. Accidental omission to serve notice. Accidental omission to give notice to or non-receipt of the notice by any member of the company shall not invalidate the proceedings at any meeting, as per Section 85, Subsection 1b of the Companies Act 1994. Frequency of the meeting of the board. As per BBS 1, the frequency of the meeting of the board shall be at least once in every quarter of a calendar year, that is, in 3 months, and at least 4 meetings are to be held in each year. The maximum interval between any 2 meetings shall not be more than 90 days. Director leaving the meeting after giving attendance. When number of directors fall below the minimum number fixed for quorum due to departure of any director giving his attendance in the meeting, the business carried thereafter will be invalid if the articles do not clearly mention that quorum is not required throughout the meeting. Director leaving the meeting in the middle of a meeting. The directors cannot transact business in meeting if at any time the number of directors present falls below a quorum, although a quorum was present at the beginning of the meeting. Business at meeting may be started if quorum is present. There is no express indication in the Act or regulation that quorum is not necessary throughout the meeting. The quorum of the board is required at every stage of the meeting. Unless a quorum is present, the business transacted is void. Restriction on interested director to form quorum. A director of a public company or a private company, which is a subsidiary of the public company, cannot vote for a resolution in which he is interested. Such director cannot be counted towards a quorum for meeting transacting such business. Some major issues from the Companies Act 1994 and the regulatory rules. From the Companies Act 1994 and the regulatory rules, the issues can be summarized as follows. A person should be nominated as chairman on behalf of all the persons to make any meeting valid. The chairman and the managing director would not be the same person. He or she can be nominated previously or instantly at the meeting. He or she is the leader of the board. He or she provides overall leadership to the board. He or she presides over the meeting. He or she is only person who is responsible for corporate governance, consulting with company secretary. He or she must be a non-executive director. Passing of a resolution by circulation. The director of a company may pass a resolution by circulation if it is provided by Articles of Association without convening a board meeting. Such a resolution by circulation must be recorded in the immediate following board meeting and will be incorporated as a part of the minutes of the meeting, minutes of the said meeting. The articles may allow directors to act otherwise than in a meeting. If the Articles of Association so provided, a resolution in writing signed by all the directors for the time being in Bangladesh shall be valid as if it had been passed at a meeting duly convened and held. Types of business not to be transacted by resolution by circulation. Not all kinds of businesses can be transacted by resolution by circulation. When a director is interested in a contract within the meaning of Section 131 of the Companies Act 1994 and the articles provided that a resolution in writing signed by all the directors for the time being in Bangladesh should be as valid and effective as if it has been passed at a meeting. A resolution by circulation approved by all directors, including the interested director, shall not invalidate due to signature of interested director. All business cannot be transacted by circular resolution. Where the Companies Act 1994 provides a particular business has to be transacted in a meeting of directors as per Section 290, disclosure of interest in respect of contract as per Section 130. So minutes. Minutes is known as recording of meeting proceedings methodically. Every motion, discussion and the consequent resolution when recorded minute by minute in a summarized description, they constitute the minutes. In fact, minutes are the summary of the proceedings of a meeting. Section 89, subsection 2 of the Companies Act 1994. Any such minutes, if purporting to be signed by the chairman of the meeting at which the proceedings were held or by chairman of the next succeeding meeting, shall be evidence of the proceedings. Share transfer. One of the major characteristics of the company is that its share can be transferred easily. Now, share of a public limited company are movable properties and transferable from one person to another in line with the provision of the Companies Act 1994 and Article of Association of Company, Section 30, subsection 1. Section 38 of the Companies Act 1994 provides the detailed requirement on transfer of share. Schedule 1 of the Companies Act 1994 also keep in mind before completing the transfer of share. Share transmission. The process of share of a person is transferred automatically to his legal successors or nominee for his death, madness, or insolvency. This process is also called an involuntary assignment. Succession certificate from the court of competent authority is the main requirement in case of transmission. Section 40 of the Companies Act 1994 provides that a transfer of share or other interest of a deceased member of a company made by his legal representative shall, although the legal representative is not himself a member, be as valid as if he had been a member at the time of the execution of the instrument of transfer. Thank you.